All right, thank you so much for joining us. We're excited to present Train the Trainer, Immigration Compliance for Businesses and Employers. We're going to kick off with introductions of our speakers. Can we please move on to the next slide? All right, I'll start off with myself. Odette Ford. I lead the Immigration Integration Initiatives here at the California Governor's Office of Business and Economic Development. I'm going to kick it off to Max.
Good afternoon, everybody. My name is Max Norris. I'm an attorney with the California Labor Commissioner, and I'll be presenting today about AB 450. Sophia?
Yeah, I can go next. Thanks. I'm Sophia Wrench, she, her pronouns. I'm an attorney with public counsel in our community development project, which assists small businesses and nonprofits. And I'll pass it to Ritu.
Hi, everyone. Good afternoon. My name is Ritu Mahajan. I'm the directing attorney of Public Counsel's Community Development Project. Thank you.
Great, thank you so much. Just wanted to share some opening remarks. The Governor's Office of Business and Economic Development is the leader in economic development, business assistance, and generally support around all efforts on businesses and entrepreneurs. We're delighted to have this webinar today. We understand that some of the information that you'll be hearing today will help you and your organization support and expand this information to business owners who might need to understand the rights and the responsibilities when it comes to immigration and immigration enforcement and laws. So we're excited to have this really exciting conversation, and we look forward to hearing from you on any feedback you may have. We're going to kick it off over to Sophia to start us off in the presentation. Thank you.
Thank you, Odette. Before we get started, we just wanted to give a brief disclaimer. Although some of us are lawyers, we're not giving you any legal advice, and attending this presentation doesn't create any sort of attorney-client relationship between us and you. If you do have a legal issue specific to you, we do recommend talking to a qualified attorney about any of those matters. We also are just presenting information that's current as of this presentation date, which is July 16th. And there may be changes to the law in the future that we can't anticipate. And we do ask that you do not duplicate this presentation, make your own recordings, either in whole or in part without our written consent or the consent of the state of California. But as Odette said, we are recording this, and we will share out the slides afterwards. To begin with, we wanted to talk about who Public Counsel are. Public Counsel, where Ritu and I work, is a nonprofit public interest law firm dedicated to advancing civil rights and racial and economic justice, and to amplify the power of our clients through comprehensive legal advocacy. The Community Development Project, where both Ritu and I work, provides free legal assistance to lower-income entrepreneurs and small business owners, as well as nonprofits who serve low-income communities. And we also engage in impact litigation, policy advocacy to advance racial, housing, and economic justice. We can also share out our online application if you're specifically in the LA area or beyond. We may be able to offer your small business services, and we can share a link in the chat at the end. Today, what we're going to be covering is some recent trends and insights. We're going to talk about everyone's constitutional rights. We're going to talk about storing and confidentiality of information. We're going to talk about I-9 requirements, audits, raids, public and private spaces, how to create and implement a policy for the business, harboring and obstruction of justice and what those mean, judicial warrants and subpoenas, and then also caring for your staff after a raid. As a reminder, this is a Train the Trainer presentation, so this information is guided at people who are assisting small businesses with understanding their rights. It's the information that we'll be sharing would apply, obviously, if you're a small business owner yourself, but the way that we're phrasing the information is guided towards people who want to give presentations like this one to others. And so just be aware that we're not necessarily covering all of the in-depth information that somebody might need in order to train someone on this, but wanted to give everyone kind of a brief overview of how to approach this information and what would be important to convey to somebody who is going to be doing their own policy for their business. And again, we welcome any questions in the Q&A as well. Also wanted to flag that this information can be triggering and it can be stressful, but we do want to arm you all with the most important information so that you feel less overwhelmed in the moment when you might have to interact with an immigration agent. And just know that we can't cover everything in this time, and that we do welcome questions as they come. So to get into it, generally, every single person in the United States, regardless of immigration status, has certain fundamental rights that come from the Constitution. And so these general rights are the right to stay silent, the right to ask for identification, the right to document and record, the right to deny entry into private spaces without a judicial warrant, and the right to ask for supporting documentation. This also is they also have the right to be represented by a lawyer in criminal proceedings. These are rights that are coming from the Constitution of the United States. For example, the right to remain silent comes from the Fifth Amendment, right to avoid self-incrimination. So because we're able to avoid self-incrimination, we have that right to remain silent. The rights to ask for identification and to document and record will vary state by state. This presentation is obviously focused on California. And so in California, we have the right to document and record in public spaces and when we're in our own spaces. You wouldn't necessarily have the right to record and document if you're in somebody else's private space and you don't have the permission of the person who owns that space. The right to deny entry into a private space comes from the Fourth Amendment, and that Fourth Amendment says that we have the right to be free of unreasonable searches and seizures. So that says that in order to gain entry or have a search of our private areas, that is where the right to privacy comes from. They need to have a judicial warrant, meaning a judge needs to give them specific authorization in order to enter a private area. And we're going to talk a little bit more about what a private area is in depth in a couple slides. And then also from the Constitution, there's the right to have counsel in criminal proceedings. But notice that it says criminal proceedings, immigration proceedings, there's no right to counsel. So anyone who is going before an immigration judge in immigration court does not have the right to counsel, and they would need to seek a lawyer on their own and pay for it themselves or get a pro bono lawyer. This is an important moment to note that we really do recommend that if somebody believes that they might have a different immigration status and they want to know more, to go now to request an immigration consultation. Not only is that important because you want to figure out your legal pathways to status, but also to know your risk. And only a lawyer, not a notario, would be allowed to or able to give you that full consultation. Once somebody is detained in immigration detention, it becomes much more difficult for them to get a consultation. And it's generally important, if you do have a pathway, to apply for that before you are detained. With that, I'm going to move on, but wanted to flag that these are all rights that everyone has, regardless of their immigration status. And these are important to remind folks throughout the presentation, and which we will do also throughout this presentation. Before any small business is visited by immigration enforcement, they need to figure out what documentation they have in their office. So you should do, as a business owner, sort of a a review of your office. And Ritu is going to talk about this public-private distinction that we talked a little bit about. But part of that is also, what information do I even have in my office in physical form, and what information is on my laptop in digital form. So the best practice for all businesses is not storing data unless you have a specific business purpose for it. And so that means that if you don't have a reason that your business needs to keep that documentation, you should not be keeping it. And so if you go through all your files and you determine, I already have some information that I probably don't need to keep, you should think about how to destroy that, either by shredding or deleting from your computer. Also think about, how long do you need to keep a file if you need to keep it? If a case is closed, for example, do you retain those documents for a certain amount of time? And the business should think ahead of time about what kind of policies they have in place. For example, Public Counsel as a law firm has certain client retention policies. We keep our documents for 7 years. After 7 years, our case management system will flag for us that we need to delete their client file. And so for both physical files and online files, if you're keeping sensitive information, that's always a risk that either you're going to be hacked, or the government will ask for it, or in some other sort of litigation, some other lawsuit, somebody would be asking for that. And if you don't want to have to divulge information that is private information of somebody else, you need to have a policy in place to delete that information and to even know what information you're already storing. So Public Counsel has some examples of client retention and disclosure agreements or policies for nonprofits specifically that you can find on our website. But also there are similar ones online for businesses that folks can look up. The other thing to think about with digital security is what kind of software the company is using. If you're sharing personal information about someone, for example, their social security number or their driver's license photo, you should not be using text messages for that kind of information. You should be using encrypted softwares. And this is not just applicable to immigration enforcement, requesting this information about employees, but this is applicable to any sort of person that may want to access your company's private information. So using encrypted softwares for text messaging like Signal, and also it's a good idea for staff to do a digital security training, which you can probably find online, so that you make sure that all of the staff at the small business are using good digital security practices. Things like not opening phishing links, not saving files to their personal computers, signing on to sketchy free Wi-Fi in a public place. All of these things kind of open up your company to security risks beyond the immigration context. Next, I wanted to talk about what does ICE even look like? And it's important to, and I saw really quickly a question, legally, how long do we have to hold on to employee files? And that's going to vary based on your business. There's no sort of set number of years that you would have to hold on to them, to my knowledge, other than the I-9 forms, which we'll talk about in a moment. So Immigration and Customs Enforcement is sort of a catch-all ICE for a lot of different immigration agencies. And all of these agencies are within the Department of Homeland Security. The Department of Homeland Security is a government agency within the U.S. government. It's our federal government. And each department works a little bit differently. ICE technically is the organization that would be in charge of immigration enforcement and removal operations, so arresting and deporting individuals in the interior of the United States, where organizations like the Customs and Border Patrol would be at the borders, points of entry. However, Customs and Border Patrol, for example, covers 100 miles from any US border, which includes our coasts. And so that would include almost the entire state of California. So often there is cross jurisdiction for a lot of these agencies. The FBI, the IRS, the DEA, US Marshals, the Bureau of Prisons, all of these federal agencies also have been deputized in the past to do immigration enforcement as well. And so you may also need to be attuned to the logos on their jackets. But the main important thing to know is just to be looking and to be aware. So on this next slide, you'll see in the bottom right corner, there's Customs and Border Patrol in these green uniforms. More and more, we are seeing ICE agents also in more militarized attire, wearing helmets and carrying large weapons. So it might be difficult to identify in a moment because it's a little bit of a scary situation if you're dealing with like if somebody who's armed. But it's important to look at their jacket and see that is actually federal officers and not, for example, local law enforcement. FPS is the Federal Protective Service, and that is the folks who do immigration enforcement at federal buildings, so at the federal courthouses or other federal offices. You might see FPS. DHS is just the umbrella organization. And they all wear a little bit different. A lot of times they say police on them as well, but they will usually say police and then with something like a subscript that says ICE or Homeland Security or Customs and Border Patrol. HSI is Homeland Security Investigations. Again, it's another department of Homeland Security. And those are the folks that are overseeing workplace operations. They are conducting transnational criminal investigations. And a lot of times we also see these folks showing up with police or sheriffs because a lot of times they are executing a judicial warrant related to a criminal investigation. And then lastly, we have the local police. So across California, local police do look similar. City police generally are wearing all blue, and they have black and white cars, depending on the city, that will say police on the side, and they'll have a logo for the city. Similarly, sheriffs are driving black and white vehicles. It'll say sheriff, and they have tan uniforms with dark pants. And then the California Highway Patrol are the folks that are monitoring our highways, the police in charge of the highways, and they wear all tan uniforms, again, black and white vehicles. And this is in contrast to, for example, all black vehicles, SUVs, or a white vehicle with either a blue, in this case, for example, or a green stripe. Those are the official vehicles for CBP, ICE, and other federal agencies, but in many cases, we have seen these folks showing up with unmarked vans more similar to this one on the left, an SUV. Sometimes they will not have plates, or they have a plate that in California, we've seen a lot of ICE officers with, for example, New Mexico or Texas plates. And sometimes they will have the fleet service tab, which indicates, for example, using a rental car. The most important thing is to look carefully and to identify who you're interacting with before you interact with them. Local police are empowered to do criminal and sometimes, depending on the area, a civil enforcement, but they're not in California empowered to do immigration enforcement to deport people. They may sometimes work to secure an area. And we have heard reports recently that when they're called by federal agents to secure an area, that they will show up as well. So it's possible that you will have federal immigration authorities along with local police in a specific area, but there is a lot of misinformation also and false reports of people saying it's ICE when it's actually the local sheriff doing a criminal investigation. You can also ask them to identify themselves. That's a constitutional right. And even if they're wearing civilian clothing or driving a civilian vehicle, you can still ask them to identify themselves, and you can document and record them. Very briefly, I wanted to talk about the Form I-9. Most businesses know that they need to complete the Form I-9. It's the document that's from our federal government that verifies if somebody is eligible to work in the United States. And it's for anyone that's employed by a company, not somebody who's an independent contractor. And it's only for people who are working on US soil, not people who are working remotely in other countries. The employer's responsibility, and to the question that was asked earlier about retention, I-9 specifically must be retained to, if the person has worked less than 3 years, it's 3 years from their first day of employment, which is their first day of pay. And if they've worked for more than 2 years, it's just 1 year after they've stopped working. Employers should know that they need to complete their portion of this and that there are options for completing the I-9s online as well as in person. And I want to flag here that there are different requirements for if you're doing reviewing the I-9 documents online versus in person. So within 3 days of the first day of pay, the employee needs to submit documentation to the employer saying that they are authorized to work in the United States. And that documentation would range, and there's a list on the I-9 form itself. So when somebody submits it, for example, their passport or their driver's license, if you're reviewing the documents in person, you're not required to keep copies of that supporting documentation. You don't need to keep in your personal files a passport or their driver's license. All you would need to do when you get their documents, you don't need to do a separate investigation. Just confirm that the documents reasonably appear to be genuine, meaning that they don't look obviously fake, and that they relate to the employee, meaning it's not a completely different name. It's not obviously somebody else's passport. After they submit the documents, then you verify them either in person, you keep that copy of the I-9 and you retain it. You also, if you're doing E-Verify is the government system, and if you're reviewing documents remotely, you must use E-Verify. And E-Verify has an online system where once they submit those documents with a photo of themselves, that would cross-reference online registries of the individual's photo, and it might flag in the system whether this person is or is not. In the past, there have been some issues with E-Verify, which is why some people choose not to use it. But if you are reviewing documents online, you must use E-Verify. And if you are using E-Verify, you do need to keep copies of their documents that have their photo on them. So it does require you to keep additional private information of your employees. A question, which I'll just say the answer rather than having everyone contribute, would be if you are required to re-verify somebody's authorization after you've hired them. So let's say that you know that somebody has DACA and it gives them work authorization and through September 1st. And the answer is yes, you would be required to re-verify that they have work authorization after September 1st. Because the standard is knowing whether they have authority to work in the United States. The reason because of this is because DACA, for example, has an end term to the work authorization. If you know that the person is not eligible to work in the United States anymore, then you would know at a certain point that they could not work for you. So after that point, you would be required to ask them for additional documentation to prove that they continue to have work authorization in the United States. For anyone else, for example, that's a United States citizen, that has other forms of status that don't expire, you would not be required to re-verify their status at any point because you would not know that their status stops working. One thing to flag for business owners also in this point is about doing an internal audit of your I-9 forms. Internal audits are not required by law, and there's also rules that govern discrimination around this. So if a business owner is doing an I-9 audit based on somebody's race, their country of origin, or they're suspecting, for example, that this person is undocumented, that would be illegal. That would be discriminatory. However, it is a good practice for business owners to do an internal I-9 audit ahead of time before any interactions with immigration authorities. And that would just be confirming whether you, as the employer, have all of the I-9 forms in order. There's no missing areas, no missing documents if you need them. Everything's completely filled out for all of your employees. I also want to talk about what is an audit versus a raid. So you might have heard about raids a lot in the news recently, but an I-9 audit would differ. An I-9 audit is a formal process that the government is going to check your documents. So it's going to check your I-9 documents. They might check your other business records, your articles of incorporation. And in order to do that, they would send you notice in the mail that they're going to audit you. So they would send notice saying, you have 3 days to comply, and we want to see these documents. And then you have time to respond. A raid, by contrast, there's no notice. Normally, the officers have gotten advance permission from a judge to enter your facility and to search for something or to make arrests. So they would already have a warrant to do this. Sometimes they would secure the exits. In this case, you would ask to see the warrant to ensure that they are staying within the confines of that. Contact legal counsel immediately, and then record and document everything. You do not have to give permission to the agents to speak to any of the employees, and all of the employees would still have a right to remain silent, to refuse to answer questions, to ask for a lawyer for themselves, and to not sign anything. Oops. How to handle an audit, by contrast, after you get the notice of inspection, which is a formal request for the documents, you have 3 days to respond. They may ask you to waive those 3 days, which is not a good practice. You just want to give yourself as much time to respond as possible. And you want to give yourself time to collect all the documents. And then rather than having them inspect them on the property itself, you can bring them the documents at their place of business. If you waive that 3-day notice, it means they have the ability to inspect and look for the documents immediately, which doesn't give you any time to kind of collect the documents and give them everything they would want. The notice will list the specific things that they need. If they inspect the documents and they find there's any errors, for example, you have more people on payroll than you have I-9s for, you would be given 10 days to remedy that. And if it is remedied, there's no penalties assessed. But if you do have violations, the penalties can range from hundreds to thousands of dollars, and consistent violators also may face criminal penalties. It can be completely random, but it can also be based on a tip-off or surveillance that they're doing. Things that they particularly look out for is, for example, you have many more workers on site than you have I-9 forms for, or you're paying a large proportion of your payroll in cash. And in one case, the bank tipped off immigration authorities that they were paying a large portion of their payroll in cash, which led them to do an I-9 audit. Again, you don't need to give ICE consent to speak to employees if they're there, and you do need to post a required notice to let people know about the audit, which Max is going to talk more about. If they do find somebody is unauthorized to work, you would be required to terminate their employment There we'll talk a little bit more about what else you can do after a raid. And with that, I'm going to pass it over to Ritu for this next portion of the presentation.
Thank you, Sophia. I know we have a lot of questions in the chat, and I promise we will leave time at the end to go over questions. And also, I will uplift some of the really important questions that are coming in to make sure you all hear the answers. I wanted to talk briefly about public versus private space and why this is important, and how you, as people who work with small business owners, can help business owners think through some of these issues before they are subject to a raid, for example. So the reason the distinction between public and private spaces is important is because under the Constitution, specifically the Fourth Amendment, as Sophia noted, we all have protections against unreasonable searches and seizures. And whether something is unreasonable depends on whether this search or seizure is occurring in a space where we have a reasonable expectation of privacy or not. And when thinking about where you have a reasonable expectation of privacy, it's thought about both objectively and subjectively. So for example, there are certain areas that, all of us would agree that we have a reasonable expectation of privacy, such as our home, such as like the bathroom, your, personal office at work. These are places that, most people expect that it's a private space and you're not going to be monitored or surveilled in these locations. Then there are places that are more public, such as, the street, parks, things that are just open for anybody to come and go. And so what the law says is in private spaces, if law enforcement, including immigration agents, want to enter these private spaces, they do need to have a judicial warrant. And if they don't have a judicial warrant, we have the right to deny entry to them. In public spaces, of course, these agents can come and go just like anybody else, and they do not need to have a judicial warrant. Okay, next slide, Sophia. Okay, so I'll come back to the public-private issue in a few slides because we're going to talk about how business owners can think through their offices and businesses to figure out which parts of it are private and which are public, and to make that very clear. We are also recommending that all businesses and nonprofits have a policy in place that staff can follow if immigration agents show up at the door. And there's a lot of reasons why policies are important, but one being obviously these situations can be very stressful and people panic, which is understandable. But if you have a policy that staff is trained on and can quickly refer to if an agent is outside, it can help tremendously. Next slide, please. So as I mentioned, it can train staff. It helps, your staff feel more safe, and as well as your clients. It also, can have the impact of communicating to immigrants that they're welcome and safe at your work sites and at your places of business. Next slide, please. So we have a sample policy, actually a few policies that we've developed, which I'll share in the chat at the end of the webinar that business owners can use to create their own. We're also we also offer free services to help business owners create policies, but the policy will have different components to it, such as it'll address where the policy applies. So for public counsel, for example, it applies at our main office and our offsite clinics. It'll also have information about the different employee roles and who's going to have that responsibility to speak with immigration agents should they show up. It's going to talk about the space and what the policy is around receiving visitors, and what specifically to do if law enforcement shows up. Next slide, please. Okay, next slide, please. And you want to make sure these policies apply to all law enforcement, including immigration agents, because as we've noted, it can be very hard to tell if the agents showing up are police or, with the federal government. And so it should just be a policy that the business owner and the staff just applies to any law enforcement. Here's just a cut and paste of one of the policies that I mentioned we will share with you. It kind of just shows you how it looks, and it has the purpose up top, and then I'll go through it in a few slides. Next slide, please. Okay, so when advising small businesses, I recommend that you help them or, point out to them that in their work sites or place of business, they may have parts of the space that are private and part that are public, right? So for a restaurant, for example, the area where anybody can come in and, look at the menu and pay for food and sit and eat, that's generally public because anybody can come in and out of there, right? But that same restaurant might have private spaces too, right? Like where the kitchen, for example, or maybe the owner of the business has an office where they sit and do paperwork and accounting. So, if you do have private spaces in your business, we recommend that you mark those as private by using signs. And then you also implement policies around those spaces to make sure they stay private. So what I mean by that is if you do have a kitchen or an office, don't just let anybody come and go in the office and kitchen. Be sure that whoever's using those spaces is like one of your staff and that the staff knows that they're not to let anybody just in the kitchen or in your office. Because signs alone don't make a space private. It also depends on your practices around it. And, I just want to point out too that even if the agents get into the parts of your business that are public, such as the waiting room or where people are eating food, that alone doesn't give them the right to then enter the private parts of your business without a judicial warrant. And the other thing I want to note is this concept called the plain view rule. So what this means is if you as a business owner or your staff has confidential and sensitive information lying around in the business and agents happen to gain entry into your business and this is something that they can just see because it's on the desk, then it's in the plain view, which means that they don't need to have any special documentation or warrant or paperwork to access that information. So that's one of the reasons why we're saying if you have sensitive information about clients or staff, that you make sure you are following practices to not have that kind of information laying around, to have it in files and locked away in a cabinet, and just doing what you can to keep it protected. The other thing to remember too is if you are in a private space, like let's say your business is private and the general public can't come in and out, if you give the agents permission to enter, like you open the door for them and let them in, then they do not need a warrant to enter your private space. So we have to be careful about giving permission because that is an exception to the warrant requirement. Next slide, please. So I'm going to skip this one because I want to have Max have enough time for his presentation, but we'll go to the next slide. Okay, so when it comes to warrants, there are different types of warrants, and the warrant that gives these agents the right to enter private spaces is called a judicial warrant. It's on the left. You'll see in the first red box, it says U.S. District Court. So these judicial warrants are issued by a judge, like a federal judge, for example. They also are signed by a judge and they have a date on them. And these judicial warrants expire 14 days after they're issued. They also have a scope. So it might say, this warrant is to allow the agents to search X office. The warrant on the right is an administrative warrant. This is a warrant that's issued by an immigration agency itself. You'll see at the top, it says, I know it's kind of hard to see, but it says U.S. Department of Homeland Security. These are not signed by a judge. These kind of warrants, these administrative warrants, do not give immigration agents the right to enter private areas. They simply give them the right, let's say it's an arrest warrant, it simply gives the agents the right to arrest this person if they're in a public area like the street, for example. Next slide, please. Subpoenas are another type of court order that, the business may be presented with. I think the big thing to remember with subpoenas is people who are served with the subpoena should immediately contact a lawyer to get advice on whether or not they need to comply with the subpoena and if they have any objections to complying. So for example, if the subpoena asks for private and confidential records, you may have some objections to the request of turning over those records because of state or federal privacy laws. And so it's important to take your time, seek counsel before you respond to a subpoena and just turn over documents. Next slide, please. Okay, so the main thing that we advise business owners for themselves and for their staff is, if agents show up, big picture, do not lie because that's a crime. Either follow whatever policies the business has in place for interactions with immigration agents or remain silent. As I mentioned, these agents do not have authority to enter any private spaces without a judicial warrant. And in our sample policy, you'll see that there's a structure to follow. So let's say you have your workforce on site. They notice there's an agent outside. They are to call one of maybe a few authorized people that, from your company have authorization to talk to the agents. Next slide, please. And these agents would be charged with speaking with these authorized persons would be charged with speaking with the agents, reviewing any warrants they have, and basically telling the agent whether or not they're going to let them into the facility. If agents are at the door, we recommend that folks stay calm, do not run. I know we're hearing a lot of stories about people running because they're scared, which I understand. But if you run, it does give these agents a reason to say that they have probable cause to stop, to arrest you and detain you. And so do not run. Immediately contact the authorized person if you're a staff member and you're not the one that's authorized to speak with the agent. Tell the agents that, they don't have permission to enter the private areas without a judicial warrant. The authorized person is going to inspect any warrants that the agent has. If they don't have a judicial warrant, the authorized person is going to tell the agent, we have a policy that says you can't enter without a judicial warrant. If they do have a judicial warrant, yes, you are obligated to comply with it, but you don't just let the agents, into your private spaces. You follow them and you watch what they're searching, making sure that they're staying within the bounds of the warrant. And you also have the right to document and record what they do. Next slide, please. I'm going to skip this one to the next slide. And you'll get all of these slides afterward, so don't worry. If you do document and record, which we advise because, if the agents do not follow the law and, for example, barge into private spaces without a warrant, you documenting and recording what's happening could be used as evidence to either, bring a lawsuit against the agents or to help in the case of any person that's detained through these unlawful activities. So announce that you're making a recording, stay a safe distance away, and, write down all the information about the encounter. Next slide, please. Next slide, please. This just pointing out that in our template policies, we do have one that gives you a template of documenting the interaction. Big picture takeaways to remind business owners is that nobody should touch the officers or interfere with them. Staff should be notified to, tell supervisors or authorized personnel immediately if agents are outside or in the facility. Always request to see a warrant. If they don't have a judicial warrant, do not give them access. Contact legal counsel and document everything. So what we're advising businesses is think about these things in advance, right? You don't want to be caught by surprise, have the agent show up and you have no plan in place. You want to have a plan in place for how you're going to deal with these interactions. You want it written down, even if it's just on a simple piece of paper. You want your staff to know what to do. You yourself as a business owner want to learn the difference between the different types of warrants. We can share documents with you after that show you the differences. And we're basically just recommending that people do their best to prepare ahead of time. Next slide, please. Okay, so of course, if a raid happens, it's a super emotional experience. It can be very stressful and traumatic. We're encouraging business owners to give their staff time to take care of themselves, to provide a space to talk about what's happened. Also, we're aware that, some people aren't showing up to work because they're scared, which is understandable. So we are encouraging business owners to be understanding of that and hold jobs open to the extent possible. And also pay wages and benefits on time. So if somebody is owed their paycheck as an employer, you are obligated to make sure, that payment is made. And so before, a raid happens, make sure all your staff are updating their emergency contact information so you know who to get that paycheck to if your worker is not showing up. If you do find that, you have people that are working for you that are unauthorized and you're worried about an audit or an audit occurs, you do have options. You can put the person on temporary leave, while they try to get work authorization. And if you do have to let them go, think about providing them separation pay. Next slide, please. Okay, so this will be in the slide deck when you get it, but there's rapid response numbers you can call, and then there's more guides. And I'm gonna now pass it over to Max, who's an attorney with the California Labor Commissioner's Office. Thank you.
Thanks, Ritu. My name is Max Norris. I'm a staff attorney with the California Labor Commissioner's Office. Next slide, please. Our mission at LCO is to ensure a just day's pay in every workplace in the state and to promote economic justice through robust enforcement of labor laws. By combating wage theft, protecting workers from retaliation, and educating the public, we put earned wages into workers' pockets and help level the playing field for law-abiding employers. Next slide. Next slide. Thank you. Just a disclaimer, similar to public counsel, this is provided for informational purposes only. We're not establishing any sort of attorney-client relationship. Make sure you consult with your own attorney if you have specific questions about practices for your employers. Next slide. As a reminder, all workers in California have rights. California's labor laws protect all workers regardless of immigration status. Workers in California have a right to file a wage claim when their employers do not pay them wages or benefits they are owed. If you need more information generally about the Labor Commissioner's Office, please visit our webpage with a list of FAQs. Next slide. California has a history of protecting immigrant workers. For regardless of the right, protection, or remedy, immigration status is irrelevant. Excuse me. Unfair immigration practices are illegal. These include demanding more or different documents in regards to I-9 verification, using E-Verify in a way not required by federal law, threatening or complaining to police, state, or federal agency, or threatening to call or calling immigration, reporting or threatening to report an employee or family status is an adverse action in the context of retaliation. And if you'd like more information about retaliation and discrimination protections enforced by the Labor Commissioner, go ahead and check this link out. Next slide. AB 450, Assembly Bill 450, was effective January 1st, 2018. This does not put employers at odds with federal immigration agents. Instead, it creates a parallel guardrail to federal law, between which is a clear path of compliance for employers. Nothing about AB 450 requires an employer to violate federal law, and the provisions of AB 450 are applicable to private and public employers. So you know to advise all of your employers. It is enforced exclusively by the California Attorney General and the California Labor Commissioner. There's a link here and in our last slide for AB 450 FAQs. Check those out when you have a chance. Next slide, please. So non-public area of labor. What is a non-public area of labor? Well, it's any area of your business where a general public is not normally free to access, right? And public counsel talked about this briefly, but why is this important, right? An employer has a Fourth Amendment right to exclude all sorts of people, including federal immigration enforcement, from those non-public areas. And as public counsel highlighted, these non-public areas need to be both in practice, policy, and hopefully also well-established signage, right? So not only is it important to put these signs up in your business, but to have a policy in place where those demarcations are actually followed, because your business may be surveilled before an immigration action, and if the practice isn't in place, it may not be a reasonable expectation of privacy. As discussed, non-public areas in a lot of businesses are usually back rooms, back offices, but it could really be the entire business, right? But we've seen that businesses with open areas have been highly targeted in Southern California. To assure your rights as an employer to exclude those that we don't want into non-public areas of labor, make sure you post those signs. Again, clearly demarcating the non-public areas, and then actually have those practices and policies in place to match the signage. Next slide. So voluntary consent is one of the exceptions to the non-public area of labor expectation of privacy, right? The other being warrants. So public counsel did a great job going over the warrants, but I want to reiterate on voluntary consent, right? This means freely asking or inviting the immigration agent to enter the area, freely opening the doors, and it tends to be a case-by-case basis. So the important thing here is, even where your staff is faced with a very scary situation and they feel that they need to give consent, the language that we use is very important, and we want to announce out loud that you're not giving voluntary consent, and instead you're allowing access due to intimidation or whatever, right? And again, this may do nothing because they're inside the doors, but where these things can be challenged later in court, those distinctions may matter. So just advising staff not to freely open and give voluntary consent, and to use clear language and have your designated folks ready to engage in that manner. Next slide. So a bit obscure, but sometimes employers will have past run-ins with immigration enforcement agencies, federal agencies, and oftentimes ICE, and where they basically enter into a settlement agreement, a memorandum of understanding with ICE about some specific use of the E-Verify system. That's going to trump pretty much everything else. So we're going to talk about some requirements for I-9 inspections and notice requirements and stuff like that. But this is kind of an overarching exemption to be aware of. You would know if your business has an MOU, because you would have had a run-in with ICE and probably sat down and settled it. Next slide, please. So the part of AB 450 I really want to highlight is Labor Code 90.2. And this is a notice requirement. So where an employer receives notice from an immigration agency, immigration enforcement agency, that there's going to be an I-9 inspection. As public counsel already pointed out, there's usually a 3-day window for which the notice is given. Well, state law under Labor Code section 90.2A requires a notice to be given, and 90.2B requires a follow-up notice if there is results given. Go ahead and go to the next slide, please. Okay, so 90.2A is the notice of inspection. This notice goes out at the time that within 72 hours, but hopefully closer to the time that the employer receives the notice from the immigration enforcement agency. There's a requirement to post a copy of the notice itself, but also to have a cover page notice in the language that you normally communicate with those employees, including the name of the agency, the date the notice was received, nature of the inspection, and like I said, a copy of the notice. Now, the cover page that the employer prepares to go with the posting of the notice that came from the federal government needs to be in the language with which the employer normally posts things for their workers. So if you normally post in Spanish, that's Spanish. If it's Mandarin, it's Mandarin. If it's English, it's English. Keep in mind that this is a requirement for both public and private businesses in California. Next slide, please. At that point, after the inspection takes place, sometimes there are results shared with the employer and possibly a follow-up inspection. Within 72 hours of an employer getting that notice from the federal government, Labor Code 90.2 sub B requires that there be an individualized notice. So backing up to A, the initial notice that's going out for is for all the employers. It's to be posted on the central place where things are posted at the business. And the follow-up notice with the results are for those folks who are actually affected, mentioned in the results, right? So the I-9 inspection results come in as a written document, usually for a follow-up of more documents or possibly a follow-up visit. At that point, the employer has to give another notice. This notice is individualized, meaning it goes to the affected employee, or if there is a collective bargaining representative, like a union rep, it can go to them. The individualized notice has a copy of the written results, basically what they got in the mail. And again, the time period for correcting deficiencies, time and date of any meeting with immigration enforcement agents to correct, a notice that employee has a right to representation when meeting with the employer. And this should be hand delivered if possible, or otherwise mailed or emailed directly to the individual, or where applicable, a collective bargaining representative. Next slide, please. Okay, so we have some more resources here for you. Our general telephone line at the top, our general website there, dir.ca.gov/DLSE. A form for the 90.2 notice that can be downloaded and used is at this link, right? The AB 450 frequently asked questions are next. And then we have a business engagement program, which does general outreach to the business community around more general wage and hour and labor related stuff. And we have brochures at this link for more general information for employers.